I'd like to talk for just a second about prior art searches. Now, a lot of people seem to think that if they don't get a prior art search, that the prior art that's out there is just going to magically disappear between the time their application is filed and the time the examiner examines their application. This just doesn't happen. And so if there's prior art out there that may be valid to whether or not you're going to get a patent, I strongly recommend that you do a prior art search before you apply for patent protection. Wouldn't it be better to know at the beginning that you weren't having a very good chance at getting a patent than to find out 2 or 3 years into the process? The second thing that I find is a lot of inventors, they try to save that $400 or $500 or $600. They try to do it themselves, or they get one of their friends to do it. And unfortunately, no matter how smart they are or how smart their friends are, they probably haven't had 15 or 20 years experience searching for prior art the way that somebody at, say, National Patent Services would. So again, our advice is don't use your friends, don't rely upon the one that you did. Hire a professional to take it over. And now, we don't do prior art searches at InterContinental IP because, quite frankly, we write patents and we write trademark applications. We don't do the prior art search section. People like National Patent Services and Legal Advantage, they have decades of experience in this. They do a fine job, and so we like to look at their results while we're writing the patent application. But again, do it yourself to begin with, and see if you can see that there's still hope at the end of your own prior art search, but definitely have your work checked by a professional before you decide to pay money to a patent attorney to write the patent application.